Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. The Honorable Supreme Court of India found an accused person as a juvenile at the time of committing the offence and released him. He has been languishing in the jail for 28 years. Now, it is established after inquiry by Pune judge that he is a juvenile at the time of offence. No doubt, the offence is very serious, killing 5 women, including a pregnant woman. But still, when once he is a juvenile, he was a juvenile at the time of offence, Juvenile Justice Care and Protection Act 2015, he will commit execution. He cannot be punished for more than 3 years. Whatever heinous the crime may be. That is the rule of law. Supreme Court upheld it. Now we'll go to the details. Honorable Justices K.M. Joseph, 3 judges bench. K.M. Joseph, Anirudh Bose and Hrishikesh Rai. While dealing with the case of Narayan Chetan Ram Choudhary. Narayan Chetan Ram Choudhary versus State of Maharashtra in CRLMP number 157324 by 2018. On 27th March 2023, just 2 days back, they clearly held that the offender was a juvenile at the time of offence, that is in 1994. He has to be released on bail. He was released. Coming to the facts of case, this Narayan Ram Choudhary, along with his 2 others, on 5/9/1994, he murdered 5 women and 2 children in Pune. One of them, incidentally, was a pregnant woman at the particular time. So it was a ghastly incident, sensational incident. So anyway, the police swung into action immediately. They have arrested him on that particular date, immediately, that is on 5/9/94. Right? So from that time onwards, he was in detention. So maybe for about 28 years or 24 years old. So in this connection, in 1998, the trial court conducted or completed the trial, came to the conclusion that he was responsible for the murder and therefore he was given death sentence. So normally, as usual, he approached the Honorable High Court of Maharashtra. High Court also declined to interfere with the judgment. So he deserves death. Then he approached the Supreme Court. Supreme Court also upheld the judgment of the Honorable High Court of Maharashtra because of death of 5 women, death of 2 children. What more heinous offense should be there to give death sentence? Definitely is allowed. But later, review petition was also filed. It was not accepted by the Supreme Court. Ultimately, see the intelligence of the advocate. An application under Section 9, Clause 2 of the Juvenile Justice Act was moved on behalf of the appellant that he was a juvenile at the time of offence. And he was, so therefore, taking to consider of the application, the Honorable Supreme Court directed the Principal District Judge Pune to conduct an inquiry regarding the juvenility of the appellant, and PDJ went to the spot. He perused the records, he has taken up the documents, he has gone through the village register, he has gone through the births and death register, he has taken the date of birth certificate from the school also. Ultimately, he concluded that this man was aged 12.5 years at the time of committing offence. But why the problem? Why? But he was mentioned as 20 years old, of course, because of personality, and also there is a little confusion in the name. So his name was written as Narayan Ram. Actually, his is Narayan Chetan Ram, but Narayan Ram, they have mentioned his name. And from the beginning, he has been telling that his father's name is Chetan Choudhary. Everywhere it is confirmed that his father is Chetan, only the difficulty in the name. Typical the name made him languish in jail for 28 years. Of course, Honorable Supreme Court of India agreed with the inquiry report of the PDJ Pune. So another point also came to his advantage. When he filed a so-called review petition, the jail superintendent of Eravada jail, Maharashtra, he mentioned the date of birth as 1/2/1982. The judge also said his date of birth is 1/2/1982, which means to say that he was 12.5 years old at the time of offence. Ultimately, now the defect has been rectified. Of course, nobody can do anything. So he has been released, no doubt. This is the rule of law. Normally we feel bad. ఏమిటి 5 మనుషులు ఆడ మనుషులను చంపి 2 పిల్లలను చంపిన వాడికి ఈ రోజున జువెనైల్ వదులుతారా? రూల్ ఆఫ్ లా ఇస్ లైక్ దట్. జువెనైల్ జస్టిస్ యాక్ట్, వాడు ఎంత క్రిమినల్ అయినా ఉండే ఆ టైంలో అఫెన్స్ చేసినప్పుడు ఆ టైంలో ఉన్న పరిస్థితి, దట్ ఈస్ వాట్ ఈస్ ది టాపిక్ ఆఫ్ ఎక్స్ పోస్ట్ ఫ్యాక్టో లాస్. So while dealing with the article, we will ex post facto laws. So we can't give more punishment for them. Anyway, good judgment regarding the rule of law, no doubt. So we should not have any place for sentiments. Normally, on saying it, manishi mandipodu 5 చంపినోడికి 3 ఏళ్ళు జైలా. But still, rule of law is there. We can't help. So, very beautiful judgment by Honorable Supreme Court of India. Please read it and enrich your legal knowledge. With this, I am stopping here. Thank you.